Hello, welcome to Artisan Realty's training session right now. This will be a 3 or 4 part training session. This will be understanding the standard agreement of sale, the contract that we use for purchasing real estate in our industry. Again, I just want to start with a little caveat here. If anyone's watching this and are trying to figure out how to fill out an agreement of sale and you're not working with an Artisan Realty, then I would suggest that you don't accept this advice as legal advice. A lot of what we do with real estate falls into the category of legal advice, and every one of these contracts is very nuanced, lots of different aspects of it. I don't want you to consider this as a way to fill out the agreement of sale if you're not a licensed agent working with Artisan. Along the same lines, if you do need help helping to fill out an agreement of sale, give us a call, explain your exact situation. We'll be glad to guide you along the way. It's an interesting and complicated contract, and lots of different things could happen along the way. I'm going to try to break this down into 3 or 4 bite-sized pieces, and this is training for Artisan Realty agents, and it will help you to understand the contract and then explain it to Artisan Realty clients, which is kind of part of our goal. So I'm going to start right here at the very beginning. Page 1, standard agreement of sale for real estate, and I'm not going to talk about how to fill it out, but talk about why things are, why they are. So this front page, if you notice, everything is in a box. The legal ramifications of that being in a box is the people who drew this contract are saying that these are parties to the contract, but they're not parties to the contract. So, for example, this is between the buyer and the seller. We're going to give the agent's name and information here, but they're not the people who should be sued in the case there's a conflict between the buyer and the seller. So the exact property would be described right here. We talked on how to fill this out about why you should use the tax ID number here, which identifies all the parcels in Pennsylvania, New Jersey, and Delaware, just so there's no question about what property we're actually selling. And then again, we're going to fill in the buyer's information. And what I'm going to get to then here is the meat and potatoes. So the buyer can represent the buyer as a buyer agent. Buyer represent buyer only. A dual agent representing the buyer and the seller in the same contract with the written permission of both parties. And then they will have obligations not to do any damage or create any harm to either parties, and to try to work with the best interest of either person. If in our company and at Artisan, if a buyer agent or a seller agent is in dual agency and they feel, or the clients feel, that they can't properly represent both parties correctly, then the broker is going to step in. Myself, I may appoint another agent to represent one of the parties. I may pay for legal counsel to make sure you have the proper representation. But when we have a situation like that, we do have some workarounds to help it out. So if it was a dual agent, you'd have that box, dual agent. Down here, there's a box that says transaction licensee. When real estate agents come out of real estate school, they're given the idea that this is a common way to sell real estate. But in fact, if you're checking transaction licensee, I'd say 99 out of 100 times you're probably doing it wrong. And I definitely want you to have a conversation with me before you do that. For example, if you're representing a seller and you're doing it as a transaction representative, you're violating 3 or 4 different codes that real estate agents have to do. For example, walk through the property, work with the seller to give them the seller disclosure information, all kinds of different things, which it goes beyond the scope of a transaction licensee. So we want to make sure we do that right. I'll probably come back and tell you, hey, represent the buyer or represent the seller, but transaction licensee just gets us in trouble. As we get down here to the seller's relationship, again, right underneath that, we have seller agent just representing the seller, dual agent representing the seller and the buyer, or seller agent with designated agency. Lots of different options there. Almost 99 out of 100 times, you're going to either represent the seller agent, seller only, or the buyer agent, buyer only. And if you're doing anything else other than that, we would have had a long conversation about how to check those boxes properly. Right here is a great definition of a dual agent, a broker, a dual agent. When a broker represents buyer and seller in the same transaction, the agents can become dual agents. All brokers, licensees, and dual agents, unless there are separate designated agents for buyers and sellers. That goes on and on and on. I'm sorry, lots of legal aspects of it. In our company, we do allow you as an agent to represent a buyer and a seller in the same transaction. However, I need to know about it. I have to be notified before you commit us in that direction. There are certain circumstances. For example, you're selling a house to a litigation attorney or someone who just sued their last seller or buyer, and or maybe I don't feel that you're seasoned enough to pull it off. But either way, I want to know about it first to see if we can give you permission to do that. So that's page 1 out of 13. We're now at the top of page 2, and you notice it says here there's a date. That is simply the date that the agreement is drawn. It doesn't refer to anything in the contract. For example, the buyer has 10 days to go get a home inspection from the date of execution. This is not the date of execution when both parties signed it. This is the date when the contract is drawn. You could start to draw it 2 weeks ago and then finally finish it today, and then not meet with the buyer for 3 or 4 weeks, and that date pretty much stays the same. On the first line here, we put in the purchase price. Obviously, we want to write it out. It's just like a check. If there's a conflict between the number and the written amount is going to supersede it. So it's something to be wary of. Always double check that if you said $110,000, that the words say 110,000 and the two jive. We'll get into the philosophies of different things here. Now, initial deposit within so many days of execution date. An execution date is when both parties have signed it. The contract has moved away from you'd have to have a deposit in writing, certified check with the offer, to, hey, you can have a contract and then give the money 2 or 3 days later. You can have a valid accepted contract by a seller, which requires a first deposit in 2 or 3 days. A lot of agents are uncomfortable with that, but this contract allows you to do that, and it's certainly commonplace in other states. In California, for example, the buyer signs an offer, the seller accepts it. Within 3 or 4 days, the buyer agrees to drop a check off. It's common in different areas. So you can have a date other than the date that this contract is drawn. You don't have to have a check with this contract, although because a lot of agents have done it different ways over many years, they're going to want to see a check, so probably give them a check. Line 2 says additional deposit within so many days. Most buyers want to have inspections and do some of their due diligence before they're putting a lot of money down on the property. So usually that date is 10, 12 days from the date that the buyer and seller accept the property. Then they get a chance to have a lot of their inspections back, maybe do some additional appraisal work, and they'll be very comfortable about giving the second deposit if they're still in it. But they may want to not give the second deposit in the case that they're having some concerns or they haven't been able to negotiate a home inspection with the sellers. Pennsylvania real estate law says that the seller can only keep money that's been deposited. So if a buyer has a problem and defaults on the contract 15 days into it, and they were supposed to give a second deposit 10 days into it, guess what? The sellers can only keep or attempt to keep the deposit that was given that has been accepted by their listing agent. Now, even if the money was supposed to have been given, it doesn't matter. It can't be used as damages in that situation. Now, I just want to go a little bit sideways here for a second. I've had lots of experiences with telling buyers and sellers that this is what the law is, this is what the contract says, etc., etc. When I say that, I say it pretty much with a grain of salt, because my experience also has been that we get into small claims court, when we get into the mediation world, wherever this contract is going to be disputed, if there's a dispute, all bets are off. Even though it says that, and different interpretations are going to be there. I had a case in the Philadelphia Court of Law where we went in front of the judge, and I said, why are you here? And I said, well, I'm here, but I don't want to be here. As a matter of fact, the contract says that these buyers who have a problem with this property should have been in mediation. The contract calls for mediation. She looked me straight in the eye and says, I don't believe in that stuff, but I'm going to hear the case. So even though the contract may say things specifically, it doesn't mean it's a law. It doesn't mean it's going to have to happen that way. Be very careful with that when you're talking to buyers and sellers. Let them know that this is pretty much, if there's a dispute, it's going to go to court or mediation to be determined by people that we have no control over. All funds paid by buyer, including deposits, will be paid by check, cashier's checks, and wired funds. Anything within 30 days of settlements must be cashier's check or wired funds, but not a personal check. There's been lots of issues with personal checks that haven't cleared for 20, 30, 40 days, sometimes never at all. There's been scams involved with personal checks where they're outside lenders outside the country basically never intend to clear them in the first place, and you have to be careful with that. So most listing agents and sellers agents insist that we have good funds in an account at least 30 days prior to settlement, and that's why that is there. Deposits, regardless of form of payment, will be paid in U.S. dollars. Obviously, we don't want to have to accept currency from other countries. The deposits must be kept in escrow account conforming with all applicable laws in Pennsylvania. If it's a broker's escrow account, That means that it's in a non-commingled account and broker can't even release it even if he wants to, unless both parties give him written instructions or a judge tells him to release it. Just a little tool here for new real estate agents. You don't have to put money in a broker's escrow account. Here's kind of a wild scenario. Let's say you have a seller who's maybe a hoarder and doesn't have any money to get all of his stuff out of there. Therefore, he can't accept a contract. It is perfectly fine for a buyer to give the deposit, make a check out to the seller. And this is perfectly fine for the seller to use that money to move everything out of their property or do whatever they want with it. They could go to Atlantic City and put it on 27 Black, in a roulette wheel. The law basically says if a real estate broker holds the escrow, we have to put it into a non-commingled escrow account. It doesn't mean that you can't give the deposit directly to the seller, and the seller can do whatever they want with it. They're selling their house. This is the money to sell the house. It's a very interesting tool to keep in the back of your head when you run into situations where the seller objects to accepting the offer because they don't have the money to move out or to do whatever they have to do. Number 3 there, seller assist. So we can fill that out. That means the seller is going to contribute to the buyer's settlement cost. A little kind of rules of thumb for an FHA transaction, the seller's maximum seller assist is 6%. If a buyer has 10% down in a real estate transaction and sometimes 5% sent down, it may be maybe a 6% seller assist. It may be a 3% seller assist. Every single time you're going to have an assist, you need to do 2 things. You need to run it by the lender to see if that assist meets the program that the buyer is applying to for his mortgage. And second, you have to be really careful that there is enough money in the transaction to actually counterbalance that assist. For example, the buyer has to have enough closing costs that they have to pay that is available for the seller to pay. Sometimes a buyer is such a great negotiator, they find a title company, they get title insurance for free. They don't pay any fees to the lender, and the contract calls for the seller to pay an assist to the buyer, but the buyer doesn't have enough charges to actually be paid for. And you're going to see right here that buyer's costs as permitted by the mortgage lender, if any. Seller is only obligated to pay up to the amount percentage which is approved by the mortgage lender. It's only obligated to pay that amount. It doesn't mean that the seller doesn't have to can sit there at settlement table and say, Mr. Buyer, I know I agreed to give you a $5,000 seller assist, and your lender is only offering to give you a $4,000 seller assist because they say $5,000 defeats the rules within the program. There's nothing stopping that seller from writing a personal check after closing a week later to give him a Christmas present or to do what he agreed to do, but just not on the settlement sheet and not in that transaction. Number 4, settlement possession date. Settlement will be such and such a date, or on or before. So if you put this on a holiday, it's going to be the day before the holiday. You put that on a weekend, it's going to be the day before the weekend. It's going to be in the county where the property is located or an adjacent county. You can't require a seller to drive halfway across the country to attend settlement, and then during normal business hours, obviously. After that, it says the time of settlement, the following will be prorated on a daily basis, and they're going to talk about taxes, interest, condominium fees. Basically, all taxes, all the fees are going to be prorated on the settlement sheet, with the exception of transfer taxes, which are generally split evenly. So there's a tradition in Pennsylvania that the seller pays for the day of settlement. So if that day, that one day of taxes, that one day of condo fees, that one day of interest, whatever it is on the settlement sheet, the seller will pay for the day of settlement. The buyer will pay from that day on. The title clerks usually take care of all that, and hopefully we're supposed to get a HUD settlement sheet a day before settlement so everybody could see the fees that are going to be prorated there. Some interesting things in Pennsylvania. There is no proration in our part of town. In Pittsburgh there is, but in our part of town there is no proration for oil left in an oil tank, gas left in a propane tank. Firewood is considered personal property. So if it's left at the house, it's considered personal property. And people from out of town, you'll see this happen. They're going to come in and they're going to expect that someone's going to be prorating or measuring the oil in the oil tank and figuring that out at settlement. That doesn't happen in this area. It's unusual. It's an unusual aspect of selling in the Philadelphia area. Along the same lines, people in Pittsburgh, when they sell and they move, they take their kitchen range with them, just a tradition. They don't do that here. The kitchen range is generally left in the property in Pennsylvania. And people who move from Pittsburgh to Philadelphia sometimes unload their kitchen range off their moving truck and are very surprised to see that there's a kitchen range in place there already. So it's just kind of a funny little thing to keep an eye on. In our region here, the municipal tax bills in Pennsylvania go from January 1st to December 31st. So county, township, sewer rent, things like that go from January 1st to December 31st. School taxes outside of the city of Philadelphia will go from July 1st to June 30th. So they're on a completely different proration, so it throws everybody off. And then in the city of Philadelphia and Pittsburgh, the school taxes are usually part of the city taxes, and they go from January 1st to December 31st. A little bit tricky to do that. There's a couple little ways to remember the differences, but just always keep in mind that the school taxes and most of the properties we sell are not going to be from January through December. They're going to have their own calendar year. Conveyance from the seller will be from a deed of special warranty unless otherwise stated here. A little bit bringing you back to real estate fundamentals, but special warranty is the one where the sellers guarantee that to the best of their knowledge, they haven't encumbered the property. They're giving clear title, and then the title company is going to step up and guarantee what the I'm sorry, not guarantee, but indemnify what the buyers, what the sellers have said is true. And if anybody was to write in there, it's not general warranty, it's just a regular warranty deed or something unusual like that. That would be something you'd want to run by the lenders and the title companies to see if they can actually guarantee that. In some parts of the country, the seller is responsible for title insurance. The seller is responsible to do all the research on the property and then give good title insurance to the buyer. In this part of the country, the buyer orders title insurance from a title insurance company, and then they ask the seller to sign that particular type of deed, tying the seller into their statements at that point. And they also sign an affidavit at settlement saying that to the best of their knowledge, they don't owe any money. They are over 18. They know what they're doing. They're of legal mind at the time that they're transferring the property. Next line here. Payment of transfer taxes will be divided equally between buyer and seller unless otherwise stated here. In the city of Philadelphia, the total transfer tax is 4%, so the buyer pays 2%, the seller pays 2%. In the suburbs, most areas, the total transfer tax is 2%, with the buyer paying 1%, the seller paying 1%. Radnor Township is an exception. Pottstown is an exception. It's pretty important that you use our Trend MLS closing cost estimates when you're working with the buyer and the seller, because they have that all factored into their computers. And if you do that, just you'll know if you are in an area where the transfer tax is not exactly 1% on either side. Also, if you're selling a bank-owned property, be careful, because most bank-owned properties require that the buyer pays all the transfer tax. So if someone's buying a bank-owned property, for example, a HUD property in the city of Philadelphia, the buyer is going to be asked to pay 4%, and the seller is not going to pay any. Line 42. Possession is to be delivered by delivered by deed. Existing keys and physical possession to a property vacant, free of debris, with all structures broom clean at the day of settlement, unless seller before signing this agreement has identified something separate. So they're important words to kind of memorize. Free of debris, with everything broom clean at the time of settlement. If someone walks in on a pre-settlement inspection and there's a couple boxes there, there's a couple tires in the back, it's not free of debris, it's not broom swept, the buyer has the option to walk away from that contract and get his deposit back. The same goes for the heater has to be working, hot water heater has to be working. Anything that was presumed to be working at the time of purchase has to be working at the time of settlement. If a seller included a washer, dryer, refrigerator in the transaction, and those aren't working at the time of settlement, guess what? The buyer can get out of it. You want to be very careful not to have a seller say, just tell them it is how it is, because that gives a buyer an out. So the best thing to do is say, I will replace it with a new washer, dryer, or refrigerator, to keep everybody bound to the contract that they signed prior to that. If the seller has identified the property subject to a lease, possession is delivered by pretty much the same thing. The lease begins with the seller on the same day of settlement, and there should be a formal assigning of the leases to the new owner. So the old lessor, the person who gives the lease to the lessee, the tenants, should assign the leases to the new buyer, and also assign the escrows. Don't forget that, and do that formally. Keep a record of it. Attach it to the agreement of sale if you're a good, keep it in your file if you're a good agent, so that doesn't become a problem. And buyers should be aware that. Should try to be aware if there's any legal action between the seller and the tenants prior to that point, to make sure that they're not buying a small claims lawsuit, or a tenant that's behind in his rent, or something like that. Number 5, days and time of the essence. Written acceptance of the parties on or before a certain date. So this is an offer made to a seller. If they accept within the period of time, then we have a contract. If they haven't, if it's after that date, if the buyer didn't adjust that, everybody doesn't sign it and initial it, then we don't have a contract. The settlement date and all their dates identified in this property are binding. They're important. The execution date is a date which the buyer and seller have indicated full acceptance. And for the purposes of this agreement, the number of days will be counted from the execution date, excluding the day the agreement was executed. For example, so if someone made an offer 3 days ago and the buyer and seller accepted that contract in writing today, the beginning of any dates that are being counted in this contract will begin tomorrow. So today isn't the first today is a 0 day, tomorrow is the first day. So as of today, the buyer would have 11 days to perform a home inspection. As of tomorrow, they would have 10 days to perform a home inspection. All changes in this agreement should be initialed and dated. So the common way to do it is to put a line through a chain so everyone can see what it is that you're changing. Put the new term above it so everybody could read it, and both buyer and seller's initial and date the date that they made those changes. The settlement date is extended by any if the settlement date is not extended by any other provision of this agreement, it may only be extended by mutual written permission of the parties. So no one can assume that they're going to settle 10 days afterwards and they're still in a contract. If everyone is going to settle 10 days later and they still want to be in a contract, they all have to extend the settlement date in writing and keep a copy of that, obviously. Another kind of a rule of thumb you want to follow with these contracts is if someone signs something, initials something, they get a copy of it. If they don't get a copy of it, you could be creating problems. Basically, we're not, as real estate agents, we're not going into a line like this. Certain times and periods are pre-printed, and we're not crossing out a line like that. That would be something you need a legal degree to do. You'd have to be an attorney. We are filling in the blanks. Anytime you're doing anything other than filling in the blanks, I think you have to talk to me, talk to your broker, make sure that you're allowed to do that. You don't want to lose your real estate license in Pennsylvania. The number 6 reason why people lose their real estate license in Pennsylvania is because they're accused of practicing law without a license. This is a contract. We can't write contracts. We can fill in the blanks. For that reason, we have these wonderful standard forms that let you fill in the blanks. Notice that every page the buyers and sellers should initial on the bottom page there. It's going to go for about another 10 minutes on this section here. So zoning. So we've got something here. This has just changed. If there's any unusual zoning, if it's regular residential, that's fine. You want to put in residential. But if you really want to be a sharp professional agent, you want to go into the public records in our Trend MLS system. And what you put in here is residential C4, residential D6, whatever the specific zoning is. So everyone has a good idea of what type of things can be done in that property. Number 7, there's a list of all the things that are included in the agreement of sale. You don't have to specifically say, for example, carbon monoxide detectors, sump pumps, garages, storage shed, fences, all those things that are generally attached to the property. But there's always some rare, unusual circumstances, things that are plugged in, but maybe they provide heat to a room, and therefore anything that's questionable in any way at all because of the way it's attached, you just write it right in here. They're also included. If you're putting in here washers, dryers, and refrigerators, it's nice to put in as is condition. It's an attempt to let the buyer know that we don't know if they're working or not, and it's on the buyers to figure that out, and it may or may not get you out of that trouble that you'd have if they're not working at the time of settlement. It's hard to say. Then if you're going to exclude something, say tagged plants, things that are attached to the property like door knockers with the seller's name on it, light switch covers, lots and lots of things that people want to take with them when they move. You want to put that right in here and have the included and the excluded things right where they need to be. So let's cover this next one, the mortgage contingency. So someone's going to have a mortgage and it's going to be contingent on them getting a mortgage. You want to click, obviously, that you're electing the mortgage. You want to put the mortgage amount, the number of years, the type of mortgage. And on line number 95 where it says the mortgage lender, if you put the mortgage company's name there, the buyer's obligated to use that lender and not to switch it later. If you leave that blank, then the buyer's allowed to go anywhere and get a mortgage anywhere in the industry. There's an interest rate cap built in here, so you might want to put 4%, not to exceed 4.5%. And basically, if the interest rate goes over that interest rate cap, and the buyer does not have to buy the property. Doesn't even matter if he is approved at that rate. This is a cap to protect him in the event of crazy moving markets. So you don't want to be too thin on that one. I think a half a point at least on top of whatever the market rate is where you want to be with that. The mortgage commitment date, line number 104, that is a date you can put in 5 or 6 weeks from on most normal transactions. So if the mortgage is not committed by that particular date, in other words, you don't have a written mortgage approval by that date, this contract is going to say that the seller will have the opportunity to terminate the contract in writing. That's not a place you want to be. You certainly would lose a lot of time and energy if the seller terminated the contract. So it says the buyer will promptly deliver a copy of the commitment to the sellers when they get it. If that commitment is vague, for example, it says 3 or 4 terms have to be fixed by the buyer, and then he's going to have a written approval or commitment that meets the terms of the contract. Then it goes on to say that from 7 days from the execution of this agreement, buyer will make a completed written, it will give what it says somewhere in there. I'll let you read the language. Sorry about that. It will say that the buyer has 7 days to correct and make it less vague. And the reason why I'm kind of dancing around this particular section is it used to be that lenders would actually issue a mortgage commitment, which would say we have definitely set aside this money for you. Nothing in the world is going to stop that from ever happening. Now their mortgage commitments are so vague they're hardly worth the paper they're written on. They're not called a commitment. They're called a pre-approval, or we assess that you probably will be able to make settlement. The lenders are not putting themselves on the hook for legal reasons, saying that they will definitely fund that loan because of all the changes in the industry, and because they don't know that they can actually fund that loan. And so many times the lenders are going to be late getting to the table with the money just because of all the checks and double checks and triple checks that they have. So basically you want to keep an eye on the commitment date. That's about all you can do as a real estate agent. Number 121, buyer will be in default of this agreement if they furnish false information to anyone concerning the buyer's financial and employment status. So if they lie to the seller but are truthful to the lender, if they lie to the lender but are truthful to the seller, it doesn't really matter. If they lie to the agents, if they give false information to any of the parties, then there's going to be a problem and they could possibly lose their deposit. When I say that, I'm going back to what I said, the earlier caveat when we started talking about these contracts. Don't ever tell someone they absolutely will lose their deposit or they may or may not lose their deposit. It's going to be determined by other people. You can just say they have a possibility of losing their deposit. When things get into the courtrooms and the mediation and the situations that present themselves after these contracts will fall apart, there's no definitive anything in these contracts. This is an interesting section right here. It's not really labeled, but I call it the get out of jail free card here. If the seller does receive a copy of the mortgage commitment by the mortgage commitment date, if the seller does not receive a copy of the mortgage commitment by the mortgage commitment date, seller may terminate this contract by giving written notice to the seller. And then down here, that thing I just mentioned about there being vague provisions in the commitment. If the mortgage commitment contains any condition not specified, buyer must settle another property, or appraisal must be received by a lender, or is not valid through the settlement date. And then the buyer is given 7 days to try to correct it. After that point, the seller can terminate the contract. And then it goes on to say here, if the contract is terminated because of the mortgage commitment, the buyer gets a deposit back. If the seller terminates it, the buyer may or may not be entitled to any costs they put out for a mortgage application and money paid to an insurance company. In addition to the mortgage contingency, now we have homeowners inspections, township inspections, appraisers going out first time, second time, third time. And if any of those things create a problem where the loan is not able to be funded, that's what all this stuff here says here. For example, property may be in a floodplain, for example, so it may require homeowners insurance. Then the buyer may also be in that situation where the buyer can terminate the contract, and all these different things will follow, in which case the buyer will probably get their deposit money back. The seller may or may not be responsible for any cancellation fees or title insurance fees. Those things rarely happen, so it's not too big of a issue, but you should kind of keep in mind that the best way I understand this contract is the buyer can get out of it about 50 different ways if they drag their feet, or if they have an insurance issue. Maybe there's a wood-burning stove in the property that's not properly installed, or floodplain issues, that affect the property, all kinds of things like that. So the most important thing a real estate agent should do is not read this contract and try to hold people to the contract, to every letter of the contract, but frankly to be very sensitive to the buyer's emotional state while they're moving forward towards settlement, and making the buyer feel valuable in the transaction. There's a million ways to get out of the contract if they want to. You don't want to have the buyer have feeling so much pressure on them that they're looking to the contract to try to get out of it, because they will find ways to get out of the contract, and there are ways for them to get their money back in every situation. This last thing, I'm going to do this and I'll take a break for a second. FHA, VA, if applicable. This number, basically to fill this out, you put in the amount of the offer and you check that box right there. And what it means in a nutshell, you can read it 100 times. It won't make any sense to you, but it doesn't make any sense to me. But what it says in a nutshell was that if the property doesn't appraise for the value that was in the contract, if it appraises for 190 instead of 200, the buyer does not have to buy the property. That's pretty much what all that says there. It's a protection for buyers of FHA and VA contracts. One more little section here. We'll go to number 9. In the event of a change in a buyer's financial status affecting buyer's ability to purchase, buyer is now obligated to notify seller and lender if there's any change. And that is so vague. Let me just give an example. Let's just say someone's working at a plant, and the plant union manager tells all the guys, we're going to go on strike. We might go on strike. We might not go on strike. And the buyer recognizes that will mess with his salary, and the lender might need to know about it. They might not need to know about it because they really don't know if we're really going to go on strike or not going to go on strike. That just puts the buyer in an untenable situation. All kinds of things could happen. They could be robbed, and they're not sure if they're going to get the money back from their insurance company. All these different situations that pop up. This is an attempt for people to try to get the buyers to be a little more forthcoming, but it's very difficult to legislate where that goes after the words are stated. It's basically going back to my thoughts about keeping the buyer's head in the game and making sure the buyer understands that we're working in his best interest, trying to get him the house and make sure he tries to stay there as long as he can. Okay, that's the end of part 1 for understanding the agreement of sale. We'll take a break right here and we'll come back with part 2.